Thanks, everyone. This is part of a book manuscript on the laws and regulations that underpin the AI revolution. I look in the book at telecommunications policy. I look at intellectual property rights. I look at smaller fry stuff like electronic signatures and digital contracts. What were the regulations that are associated with the blossoming of AI? I take a historical perspective and also an analytic approach where I use microeconomics and industrial organization and political economy to make sense of those regulations. How do we get to the AI revolution? The mediating factor here between the laws and regulations are digital platforms, I argue. And why is that the case? Well, there's a problem. We need a lot of data, and we need diverse data and natural data, behaviorally induced data, for these applications like ChatGPT to fool us into thinking that it's human-like. So context matters, coherence matters, nuance matters, and so this kind of data helps the AI train and generate the human-like responses. What's the solution? There are several, but a very powerful one are social media platforms and e-commerce platforms. They have the vast data, they have the diversity of data, and they have the behavioral data in that it's user-generated and natural. So scale and behavioral data. Social media, search history, purchase behavior. These are helpful because they're more natural, more human-like. We might take for granted that these things exist. What are these things? Digital platforms. But maybe we shouldn't. So let me explain what they are first. A lot of you might gloss over at this point because you know what I'm going to say, because you interact with these things every day and you're experts here. But I think it's important to go dimension by dimension just to think about how laws and regulations made this possible. So network effects, there's two direct network effects. More users means more users are attracted. Indirect network effects, more users means more advertisers, more app developers, hardware manufacturers, OS developers glomming on because of the users. It's a flywheel, and it just gets bigger and more powerful because of that. Obviously, a massive user base is the outcome of that, with billions of users around the world. We get high market concentration. Few players dominate the key platforms or the key areas of exchange. The network effects and the massive scale allow these digital platforms to collect, process, monitor, and distribute a lot of data, which is very attractive if you are training an LLM model, obviously. Another thing that maybe we lose track of is the ecosystem idea, where there's very tightly integrated ecosystems in terms of hardware, software, different applications. A bundling of services. Google is the biggest example I can think of in terms of you go to the Google universe and it's hard to get out of there. Less interesting than the Marvel universe or other universes, but once you're in there, it's like seamless to operate between the different applications. And then algorithms are used, obviously with AI, to get folks addicted, let's just be honest. I could use euphemisms like engaged and this and that, but addicted, right? Stay on here as much as we can to mine the data, right? Okay. I'm going to talk about how we got here in terms of an antitrust revolution that set the foundations for the AI revolution. The two key points here on the timeline, the height of populist antitrust, which is let's take a hammer to anything that's big, even things that are small. If it smells like big business, or if it's hurting small retail, or if it's hurting labor, or if we don't like it. Here's a very simple argument. Had we continued on this path, we would never have gotten to this path. It makes sense. It's tautological in a sense, right? Had the 50s and 60s endured and we kept the populist tradition intact, there's no way We would have Android with all the Google apps and Apple and its universe, and I would argue AI the way we have it today. So my task is to say, well, how did this evolve? And how is my explanation different than other explanations for how we evolved to get out of this skepticism, if not hostility, to the digital platform era? We'll talk maybe during Q&A about its return. The populism has returned. What does that mean for AI going forward? I have no idea. Let's see how it goes. But maybe the past will give us an indicator of what is to come. I don't know. We'll see. Okay. The conventional wisdom, a cabal of right-wing professors got in everyone's business and told them how to do antitrust before we had democratic antitrust. And then these, I don't know, professors, instead of minding their own business, they told courts that you need to think about consumer welfare. You need to think about things like prices and innovation. Forget about all this other stuff about big business being bad and labor and all this other stuff. The problems with the conventional narrative, and here's where I hope I add value. First of all, the drift away from populism predates the Chicago School and these nutty professors by decades. Second, courts were already deploying economic analysis in a very clumsy, primitive way, but they were forced to do it right off the bat with the Standard Oil case of the early 1900s. So, in fact, it's really interesting. The causal arrow is more about cross-fertilization, where courts needed help because they had thought about these problems. And then folks in the Chicago School and other economists are like, oh, career path, or I can go on TV, or maybe I can become an expert witness. Let me get into this racket. Another thing is that what actually ended up happening is more about Schumpeter and creative destruction and less about the static equilibrium models of the Chicago School. And so if you actually look at the court decisions that have mattered the most, especially for digital platforms, it's more Schumpeter, Austrian economics, evolutionary economics, less static price theory. What I do, it's the maybe simplest research design, so I might get a lot of flack. I read all the cases, and I decide, I don't even ask AI to help, what's going on? And what I've learned is that ideology had nothing to do with stuff. It's like courts in the early 20th century and beyond, they're like, what the heck do we do with this lawsuit? These market realities we're confronted with were like broaching in the dark for help, and economics is like light bulb could help because they're talking about this stuff. But it's more like Hinduism than it is monotheism. It's not like the Chicago School. They're waiting for the Chicago School to arrive in the late 70s. They're like, well, this idea about prices with supply and demand, that seems helpful. This industrial organization analysis of how firms operate, let's look at that too. Game theory, oh, well, strategic behavior seems to matter for firms. And then, as I just mentioned, Schumpeterian economics for innovation. And then, as courts tend to do, because they're in the business of law, not economics, let's actually look at the statutes and legal precedent and try to make our way out of this dark room. So, oh, I'm not at 5 yet. So I could have stopped on this slide if I was over time, but this is what I'm going to argue. This is what I argue in my chapter. Courts are going to recognize way before the Chicago School that there are certain benefits to things that look illegal. They're going to decide, oh, maybe we need to define a market based on the substitutes. Like, that's a good idea. Let's try that out. Oh, market power. Whoever wrote the Sherman Antitrust statute in the late 19th century was probably not an economist. Now we're confronted with this nebulous term. Let's look to supply and demand, and maybe we'll figure it out with math. Interesting idea, right? Then it's like, oh, are monopolies actually bad? Maybe it's what monopolies do that's bad. Maybe monopolies themselves are not. In fact, maybe we should encourage monopoly. Because this guy Schumpeter says that monopoly is capitalism and capitalism is innovation. The search for monopoly profits is what drives technological development, and that might be good for society. I am not, by the way, casting a normative judgment on whether that's true. I'm just saying that they were influenced by this line of reasoning, right? Or whether it should be true, is what I mean. And then you start to see these decisions that not only tolerate monopoly, but encourage it, which is crazy. We go from trying to stamp out monopolies to saying they're good. Encourage them, just as long as they don't do nefarious things once they have that power. So practices that were per se illegal in the early 20th century, courts start to erode this idea slowly but surely. Well, let's do a cost-benefit analysis. All of these, tying exclusive dealing, vertical restraints, and below-cost pricing, are going to matter a lot for digital platforms. For courts to allow this means that a company like Google can tie its products together, have an exclusive deal with Apple on the iPhone as the exclusive search engine. Vertical restraint, meaning it has power over the App Store and what happens there with folks that develop applications and how they sell apps and process payments. Below cost pricing, Amazon. Well, maybe that's not bad. We used to call it predatory pricing. Maybe there are reasons why that's good for efficiency or innovation. Also, courts decided businesses can have their day in court and defend their actions and argue for why these are important. And courts began to do this cost-benefit stuff. So here are important cases before the Chicago School with exclusive dealing, bundling or tying, and vertical restraints in terms of telling, let's say, retailers or distributors what you can do in terms of your behavior or pricing. All of these three court decisions were extremely important for setting the precedents for big tech today. And these themselves evolved over decades. These were the culmination of cases that started to tolerate this stuff and say, maybe this is okay. Another thing is, well, maybe the specific market where the competition is happening matters, not just whether you're a big firm. This was a very important case where it's like, well, maybe the substitutes for the product are important. And therefore, once we define the market, we can figure out whether big is bad. Maybe big has a lot of substitutes and it isn't necessarily bad. What's really interesting is that this focus led to a cottage industry in economics around understanding the counterfactual of what a competitive market would look like in terms of substitutes, even if it's not a competitive market that the court case is about, which blows your mind once you start looking. It's like courts move the needle. So the causal error was a lot like courts are like, we need this counterfactual, economists respond, incentives matter. Okay, let's figure out what that means. And so there's a whole toolkit that evolved once courts decided substitutes are the way you define a market. Even more important, market power, what the heck does that mean? Courts grappled with it. At first they're like, well, market share, maybe. But then they're like, well, could it be the control of supply instead of market share? 1945, way before Milton Friedman was on television talking about this stuff. Milton Friedman, the godfather of the Chicago School. And then the court, in a cross-fertilization type of situation, helped push the needle or move the needle when it comes to measuring market power. And it got better with the help of economists in doing that. One thing I love is looking at this case, it's like, oh, a monopoly. Could it be monopoly pricing? Well, what does that mean? Well, that means that if we use this formula from 1939, we can figure out if the margins are actually commensurate with what a monopoly would do, rather than a firm with just competitive advantage. Light bulb, now we can measure market power using math. That's kind of cool. So that's going to set the foundation for, as I argued earlier and as I'm arguing here, eventually digital platforms where it's like, if it's about price, we don't worry too much. Great. Let me see. Oh, let me just say here, this was an important case where the court said it's not necessarily monopoly that matters, but what you do with the monopoly. Monopolization became a verb. That it's like, are you untoward with the power you have? We won't punish the power, just the behavior, if it's bad, that comes from the power. And that naturally, I argue, or organically led to Schumpeter, where it's not only that monopoly is necessary but not sufficient, but maybe we should actually encourage monopoly, because as Schumpeter says, in terms of creative destruction, it's what attracts business acumen and what leads to the risk-taking that leads to innovation. So it came full circle from banning monopoly, if you think of Standard Oil, to this is a good thing. Let's encourage it, especially if it's the kind of monopoly that leads to innovation. The only graph I have 2 graphs in the paper. Here's one. I use text analysis to show innovation mattering with mergers, with antitrust behavior. And then with mergers, by 2010, you're recognizing innovation matters a lot, and you're acknowledging that there are these platforms and we have to make sense of them. I'll just end here, I guess. This case was very important. It was about credit cards. It was decades of struggle in the courts to figure out what to do about platforms. And this, in a sense, summarizes what digital platforms do today. 2 sides of the market. It's not just the cardholders and the merchants separate, but together they interact. When you define the market, you've got to think of that interaction. So you can't just define it as the credit card holders or the merchants, but both. It's very dynamic. Proof of harm, it can't be that just merchants goes crying to the court and sue the credit card company, because if the cardholders benefit from the cardholder behavior, then it's okay for merchant fees to go up, let's say. And then the court realizes that all these practices that seemed illegal before might be good for consumers, like ecosystems, integration, bundling, exclusive dealing. It all comes together with platforms, and that's going to really set the stage. And this was kind of a lagged situation because precedent had already encouraged platforms to do this. This, in a sense, just codified this tolerance, if not encouragement, for these business models. Okay, that's it. Keep going.
Okay, I'm going to ask the first question, and then I'll move to the back. So I have 2 questions. One is, so this paper was very long. It was about 70 pages with only 2 figures. And I find law extremely boring, but I enjoyed it very much. And I'm going to tell you why.
Fair enough.
So you convinced me. I think that, like, I'm now glad, even little did we know, that I think this paper is in a really good position to be discussed after the more behavioral ones. Mm-hmm. Because the question that I was thinking all the time was, first of all, I was very fascinated by this history of US antitrust law, which I had no idea about. But in my mind, the key question is, what do people think about this? Do they have the more populist approach, or do they have the more consumer welfare approach? And do they understand these trade-offs? Because I think now there is big talk about, and I want to hear what you think, like big tech being bad. And I'm not going to argue, I don't know politically if that might be bad. But from an economic point of view, I think it's not that easy to argue that it's bad, because yes, there is market concentration, but they don't really act like monopolies. They don't restrict supply. The prices are actually the lowest we've ever seen. I mean, if we think
for
of
that
Amazon,
side of the market, for the consumers,
right? For the
not for advertisers necessarily.
No. I'm talking about consumers. Yeah. And so and probably they do more innovation than any other actors. So I do think that I would like to know whether people know all about this, about all these trade-offs, and what decisions they would make once, if you made them aware. Okay, if we do break them up, one result could be less innovation, which could mean higher prices. So that's my first question. And then the second is more, and I'm going to try to be quick. It's going back to the California law that is right now with Governor Newsom, SB 1047. I think one interesting thing is that, so I want to ask you if you know about it, if you think that that's moving in the populist direction or not, because I think the argument is that it's supposed to technically lead to more responsible AI and guard against, and people who know more can correct me, I'm not a lawyer, guard against cybersecurity attacks. But there is a letter actually here from scholars at Caltech saying that law is going to be very bad for innovation. It's going to be very bad, especially for researchers, for individual researchers, because they're going to be responsible for the AI they produce. And Democratic politicians like Nancy Pelosi, Ro Khanna have actually expressed their opposition to this regulation, which I think is fascinating and goes back to the Republican versus Democrat. Right. Sorry, I'm going to shut up now.
Okay. In terms of the behavioral stuff, I have no idea what people think. This is fodder for everyone to hopefully innovate and produce some cool research designs and some evidence on that. My own intuition is it's not as complicated as like understanding the learner index I showed you and like how supply and demand works. It's more like government, don't take this away from me, I like it, or government, this is driving me crazy, do something. That's what I think people, like personal experience. That it goes back to like, do you understand the micro and macroeconomic effects of these regulations, or like the downstream effects of allowing this and having these huge platforms? Not really, but I know that I like to like do emojis or whatever. I didn't even say it correctly. It's showing my age. And so that's good or bad. So that's my intuition. It'd be really cool to adjudicate between more big picture. Do we understand the mechanics of the economics? Do we understand the downstream effects for the economy itself? Or is it just personal experience? On the second point, as a normative statement, I believe regulation before commercialization is bad for two reasons. The first reason is that what is the problem we're seeking to solve? Unless you commercialize a technology, you don't know what that problem is. So you've literally put the cart before the horse, and that's usually bad because then the horse can't move. Okay, the second is if you regulate before commercialization, you regulate in the wrong direction and everyone just goes this way because this is where the market was heading, and your regulations are really dumb. Hayek would agree with me because Hayek would say we just don't have the information yet. And that's just a matter of like, it just takes time, so be patient. That's my normative view. In terms of like what we should do, based on my normative view, I have no idea. That's what the politicians and everyone that went before me has much more to say about that, I would just say. But if someone came to me and asked me, I'd be like, that's just really dumb. You're just not patient. And the trade-off is you're gonna make mistakes, and you're gonna look really stupid in 20 years, I'll just say that. Like if you look at a lot of internet regulations today, you're like, what was that about? That just did not anticipate the problems. Who's calling on the? Sorry.
I just wanted to push a little more to understand your argument. So you have this argument about the historical trajectory of antitrust law leading up to platform markets. And you started with this argument about that's led to data agglomeration, which has set the stage for AI. And I'm wondering, it seems to me like I could imagine a world, like a counterfactual world where we didn't get so much, I mean, maybe platforms are natural monopolies anyway, and so we would have had it anyway. But where the data is much more spread out. And nonetheless, like AI is its own kind of, like the fixed costs of AI through compute build a natural moat and are natural monopolies anyway. And a world in which the data wasn't already agglomerated, the AI part would have happened anyway because there's Schumpeterian rents to be had, but they would have had to pay for the data.
Yeah.
And so, it's not clear to me. It's not clear to me we don't get the innovation, and maybe we get a different distribution of rents.
I totally agree with that. You're right. I should qualify my statement based on what you just said. The fixed and marginal costs are higher if it's not agglomerated with the network effects through the digital platforms. I think that's true. And another thing I think is that the scale, the diversity, and the naturalness are just much noisier. And so we get a clunkier AI that probably progresses at a slower rate. Maybe that's a good thing, and that counterfactual world is interesting. So I suppose the way I presented it isn't doing justice to your nuance, which is very well taken. And to be honest, I kind of argue that in the paper, but maybe what I need to do is bring it to the fore and just to be more honest about the limitations. Absolutely right. We would have had web crawlers figuring this out. That'd be a good experiment. Can you produce LLMs that are just as good? Maybe now you could, but maybe not 5 to 10 years ago.
Okay, so we're going to collect two more, and then you're going to answer very quickly.
Okay.
Yes. Victor, sorry, I missed the very beginning of your presentation, so I apologize in case you say something about it. I was thinking about what would be the parallels with the European approach to competition policy, the European Commission. I mean, on the one hand, we have this idea that dominant position per se is not an abuse, but what we punish is the abuse of a dominant position, which I think goes a little bit in parallel with what you are saying. On the other hand, if you look at all the cases of EU Commission versus Amazon versus Google, etc., it seems that the approach is a little bit radically maybe different in respect to the United States. And every time the EU Commission does something around those lines, the typical thing you hear from the States is like, okay, you go after Google and Amazon just because you don't have digital champions, and that's a very protectionistic approach. Okay, maybe I'm biased, but I see that as protection of competition and consumers. I don't know if you want to draw any parallel or you have anything to say about it. Thank you.
I think it's a great question. Should I wait? Oh, sorry. Okay.
Sure. My question actually builds on what Ethan was saying. So when I see this kind of like type of monopolies, like I usually think about, as you were saying, this horizontal integration with like the sellers and whatnot, like for example, Amazon, and having like a big platform from the sellers. I think this is kind of like a horizontal integration by coercion, in the case that, for example, we observe that, well, if I'm not in this platform, I'm kind of like, I can be priced out of the market, I might not have enough demand, and my product might not be available to other consumers. And so I was wondering, in the case of what you're saying, if this ties the hands to reform antitrust to reduce market concentration, and if so, in which cases these could happen. And part of what I was thinking about this is that, so for example, you might have the cases of the big tech companies where like we might benefit, like we don't have the counterfactual that what would have happened they had not been this level of concentration. And I think about it because essentially you have like a lot of startups are starting with potentially low fixed cost. Like they're starting there, they're like growing, and then suddenly this company says, here is, I know, $1 billion I'm going to buy you, and now I vertically integrate it, and this gives me much more power to keep pushing this horizontal integration by coercion. And so I was just wondering, what are your thoughts on that?
Great. For both of these? The first one about Europe, I think that trade-offs, the European approach seems to me, and I'm not an expert at all, more administrative and quicker, whereas in the US, courts are slow and it's kind of a dialogue, it's dialectic. And so I would say that you don't get AI the way you have it now with a solely European approach. I do think that Europeans would have found a way to kill the baby in the crib, because in the US, due to common law and due to the dialectical nature of the cases, you can have defense lawyers, have economic experts come and say, listen, this stuff is actually good for consumers. It just seems terrible and nefarious. Whether they're right, I have no idea. They just argue whatever they are. So I actually think the structure of incentives and opportunities to move in the direction of digital platforms is more amenable in the US case. The European, the superior European value added, I suppose, is in the fine tuning with stuff like privacy, and maybe with stuff that wasn't caught with the US agencies, where they're more risk acceptant or have been before neopopulism. The Europeans are good at risk aversion and actually maybe finding harm in that basket that had gone through, sifted through in the US. So actually maybe both are necessary, and that's something to pursue outside of the scope of this. This question is really interesting, vertical integration. I think the courts think that coercion is a virtue, not a vice. They read the industrial organization theory around vertical integration and vertical restraint, and they learned, I think, like Williamson and before him Coase, that coercion is actually fine if it leads to consumer benefits or efficiency. So actually, they probably would never want to admit that, but if you look at the decisions, they're like, well, a little bit of making the sausage in an ugly way is okay if the sausage tastes good. And then you said, what's the counterfactual without vertical integration? I do think that that counterfactual goes back to Ethan's first point, which is clunkier AI, because you wouldn't have gotten the scale economies, network effects, integrated ecosystems, and seamlessness. And so therefore you don't get the scale, you don't get the diversity, and you don't get the naturalness of the data. So it's kind of the same answer to the first question. Okay.
All right, thank you.
You're welcome.